Before we dive in, it is critical to understand that this presentation is for informational and educational purposes only. I am not an attorney, and the information provided in this video does not, and is not intended to, constitute legal advice. This video is not a substitute for obtaining legal advice from a qualified attorney licensed in your state or jurisdiction. The laws surrounding employment can be incredibly complex and vary significantly from state to state. You should always consult with a licensed attorney for advice regarding your individual situation. The meeting request just says, catch up. No agenda, no context. It's from HR and your boss is on the invite. Your heart starts doing that thing, that low, heavy thud you can feel in your throat. You walk into that small, windowless conference room, the one they always use. And before a single word is spoken, they slide a folder across the table. They use words like restructuring, realignment, difficult decision. It's a blur of corporate jargon that all means the same thing. You're out. Your access is cut off before you're even back at your desk. They hand you a box. In 15 minutes, a decade of your professional life is over, and you're standing in a parking lot in the middle of a Tuesday, holding your sad little box of personal effects, wondering what in the world just happened. Your mind is racing. How will I pay the mortgage? What about health insurance for my family? What will I tell people? My reputation, it's all gone. And amid that tidal wave of panic and humiliation, a tiny voice might whisper, "Was that legal?" You push it down. Of course it was. This is America. It's at-will employment, right? They can fire you for any reason or no reason at all. So you do what most people do. You go home. You update your resume. You start scrolling through job boards. You try to move on as fast as possible. And in doing so, you make the single most catastrophic mistake of your entire career. Because what you don't realize is that the moment that conference room door closed, a secret clock started ticking. It's not on your phone. It's not on the wall. But it's counting down second by second to the moment your rights, your leverage, and your chance at justice evaporate forever. This video is your wake-up call. We are going to talk about that hidden clock. We're going to talk about the precise moment you should even think about contacting an employment lawyer after losing your job. And I'll tell you right now, the answer is so much sooner than you think, and the consequences of waiting are so much more severe than you can possibly imagine. This isn't just for people who think they were wrongfully terminated. This is for anyone who has been laid off, downsized, restructured, or let go. This is for the person who got a severance agreement slid across the table and was told to sign it within a week. This is for the person who was told their job was eliminated, only to see it reposted online 2 weeks later under a slightly different title. The fundamental truth you need to understand is this. When you are let go, you and your former employer are no longer on the same team. They have immediately shifted into a mode of pure self-preservation. Their goal is to get you out the door as quickly, as quietly, and as cheaply as possible, while minimizing any legal risk to the company. They have a playbook. They have HR professionals trained in this exact scenario. And most importantly, they have a team of lawyers who drafted the documents you were just handed, who coached the manager on what to say, and who are on standby to defend the company's actions. They are playing chess, and they've already planned their first 10 moves. You, on the other hand, just had the board kicked out from under you. You're in shock, you're emotional, and you're completely unprepared for the game you're now forced to play. Let's talk about that ticking clock. In the legal world, it's called a statute of limitations. It's a deadline set by federal or state law for you to file a formal complaint or a lawsuit. If you missed that deadline, your claim is gone. It doesn't matter if you have a mountain of evidence. It doesn't matter if your boss admitted in writing that they fired you for an illegal reason. If you are one day late, the courthouse door is slammed shut in your face permanently, and these deadlines can be shockingly short. For some types of federal discrimination claims filed with the Equal Employment Opportunity Commission, or the EEOC, you might have as little as 180 days from the date of the discriminatory act, the day you were fired. That's less than 6 months. Sounds like a lot of time, but it's not. Why? Because you don't just snap your fingers and file a claim. An attorney needs time to evaluate your case. They need to gather evidence, emails, performance reviews, company handbooks, text messages. They need to interview potential witnesses, whose memories are fading with each passing day. They need to research the specific laws that apply to your situation. They need to draft a formal complaint. This process takes weeks, sometimes months. So if you wait 4 or 5 months just to make that first phone call, you may have already waited too long. A good lawyer might not even be able to take your case because you haven't left them enough time to do their job properly before the deadline hits. You've effectively sabotaged your own case before it even began. But the statute of limitations is just the most final brutal deadline. There are other softer deadlines that are just as dangerous. The first one is the evidence deadline. The moment you are walked out of that building, you lose access to everything. Your company email account? Gone. The shared drive with the project files that prove your amazing performance? Gone. The internal chat logs where a manager made an inappropriate comment? Gone. Your employer now controls all the evidence. And while you can legally request these things later in a formal process called discovery, it's infinitely harder. It's an uphill battle. The best time to preserve evidence is when you have it. The very day you are fired, you need to be thinking like a detective. You need to be documenting everything. What was said in that meeting? Who was there? What reason were you given? Write it all down while it's fresh in your mind. The details you remember an hour after being fired are 1,000 times clearer than the details you'll remember a month later. Did you have any prior conversations about your age, your gender, your race, a medical condition, or a recent pregnancy? Did you recently report harassment or blow the whistle on something illegal? These aren't just painful memories. They are potential pieces of a legal puzzle. Without them, even the best lawyer is flying blind. Then there's the most immediate and tempting trap of all, the severance agreement. That document they slid across the table isn't a gift. It's a contract. In exchange for a few weeks or months of pay, you are almost certainly being asked to sign away your right to sue the company for literally anything, ever. It's called a general release of all claims. You are giving them complete legal immunity, and they are counting on you to be too scared, too desperate for the money, and too intimidated to do anything other than sign on the dotted line. They will often put a deadline on it. You have 7 days to sign this, or this offer expires in 21 days. This is a pressure tactic. It's designed to stop you from thinking clearly and to prevent you from doing the one thing they fear most, showing it to an attorney. If you are over the age of 40, a federal law called the Age Discrimination in Employment Act actually gives you specific rights here. It requires your employer to give you at least 21 days to consider the agreement, and another 7 days to revoke your signature after you sign it. They also have to advise you, in writing, to consult with an attorney. Why? Because Congress recognized that older workers were being unfairly pressured into signing away their rights. But here's the key. Even if you're under 40, that principle still applies. Rushing to sign a severance agreement is almost always a mistake. That offer is often the starting point for a negotiation, not the final word. An experienced lawyer can review that document and immediately spot the red flags. They can assess whether the amount being offered is fair, or if it's a lowball offer designed to buy your silence cheaply. They can negotiate for more money, for continued health insurance, for a neutral job reference, or for a change in the reason for your termination from fired to resigned. These changes can have a massive impact on your future job search and your financial stability. But you only get that chance if you don't sign that paper right away. You only get that chance if you pause, take a breath, and get a professional opinion. So let's be crystal clear about the value you're going to get right now in this video. This is your new playbook. We are going to dismantle the entire post-termination timeline. We will give you a step-by-step guide on what to do and what not to do in the first 24 hours, the first week, and the first month after losing your job. We will cover the specific red flags that scream illegal termination. We'll talk about the exact documents you need to gather. We will explain how to find the right kind of lawyer and what to expect during that first consultation. This isn't about encouraging you to sue your old company. The reality is, most employment disputes are settled out of court. This is about shifting the balance of power. It's about transforming you from a victim of circumstance into an informed participant who understands their rights and their options. It's about ensuring you don't leave money on the table, that you don't sign away your rights for pennies on the dollar, and that you protect your long-term professional reputation. The question isn't just, how soon should you contact a lawyer? The real question is, how much are you willing to lose by waiting? And by the end of this, you'll know that the answer is far too much. Let's break down exactly what you stand to lose, because it's not just money. It's evidence. It's witnesses. It's leverage. And most critically, it's time, a resource you can never get back. In medicine, they talk about the golden hour, that critical window after a traumatic injury where prompt medical treatment has the highest likelihood of preventing death. In the world of employment law, the same principle applies. There is a golden window, sometimes hours, sometimes days, rarely more than a few weeks, where your ability to protect yourself is at its absolute peak. After that window closes, your options begin to narrow, and the path to justice gets exponentially harder. Every single day you wait, the company is using that time against you. Their machine is already in motion. Their HR department and their legal team aren't sitting around wondering what to do. They have a playbook they have run hundreds, maybe thousands of times before. And step one of that playbook is to control the narrative and erase the past. While you're at home, reeling from the shock, trying to process what just happened, they are meticulously cleaning up. Think about it. Where is the evidence of your wrongful termination? It's on their servers. It's in their Slack channels. It's in the email archives. That performance review where your manager praised your work just a month before they fired you for poor performance? That's on a company computer. That email chain where a supervisor made an inappropriate comment that you reported to HR? That's on their system. The chat logs where you discussed unsafe working conditions with a coworker? All of it is on their property, under their control. And every company has a document retention policy. It might sound boring, but it's a devastatingly effective legal weapon. These policies often state that emails are automatically deleted after 30, 60, or 90 days. Slack messages might vanish in a week. It's not necessarily illegal for them to do this. It's just standard procedure. But the effect is the same. The evidence you need to prove your case simply evaporates, gone forever. When you finally decide to act 3 months later, your lawyer will send a letter demanding they preserve that evidence, but the company will just shrug and say, "Sorry, our policy is to delete emails after 90 days." It's already gone. And just like that, the smoking gun has vanished into thin air. Let me tell you about a case that illustrates this perfectly. Let's call her Maria. Maria was a top sales executive at a tech firm, consistently exceeding her quotas. One day, she announced to her boss that she was pregnant. He smiled, congratulated her, and said all the right things. But over the next 2 months, her biggest accounts were slowly reassigned to a male colleague. Her travel budget was cut. She was excluded from key meetings. When she asked why, her boss gave her vague answers about restructuring and shifting priorities. Then, a week before she was scheduled to go on maternity leave, she was called into HR and terminated. The reason? Failure to meet performance expectations. It was a complete lie, and she knew it. She was devastated and overwhelmed. She had a baby on the way and just lost her income and her health insurance. She thought, "I can't deal with this right now. I need to focus on my health, on the baby. I'll deal with the legal stuff later." Later turned into 4 months. After the baby was born and she had a moment to breathe, she contacted an attorney. The attorney immediately sent a preservation letter to the company. The company's response was a masterclass in corporate stonewalling. The emails from her boss reassigning her accounts? Deleted, per their 90-day retention policy. The records of her sales quotas, which would have shown she was a top performer. They provided a summary spreadsheet, but the raw data, which would have proven her success relative to her colleagues, was no longer accessible after a system upgrade. The one friendly coworker in accounting who knew Maria's numbers were great and had offered to help? He'd been laid off in a subsequent restructuring and didn't want to get involved. Maria had a clear-cut case of pregnancy discrimination, but by waiting, she allowed the company to methodically erase the paper trail. The case became a he said, she said situation, which is infinitely harder to win. Then there are the witnesses. The moment you are fired, you become a ghost within the company. Your colleagues, even your work friends, are now in an incredibly awkward and dangerous position. They saw what happened. They heard the comments. They know the official reason for your firing is nonsense. But they still have jobs to protect. They have mortgages to pay and families to feed. In the first few days after you're gone, their sense of injustice is fresh. They're angry on your behalf. They might text you and say, "This is so wrong. Let me know if you need anything." That is the moment. That is the window. Your attorney can reach out to them while their memory is clear and their willingness to help is high. But if you wait weeks or months, that fire of injustice cools. Fear creeps in. They see someone else hired for your job and life moves on. They start to worry. If I get involved in this, will I be next? Will management see me as a troublemaker? Their memory gets fuzzy on the details. "I don't really remember the exact date he said that," they'll say. Their desire to help is replaced by a desire to stay out of it. By waiting, you're not just losing evidence, you're losing the human element of your case. But the most brutal, the most unforgiving consequence of waiting is something called the Statute of Limitations. This is one of the most important concepts you will ever hear about your legal rights. A statute of limitations is a legal deadline, a hard cutoff imposed by law, for you to file a lawsuit or a formal complaint. It is not a suggestion. It is not a guideline. It is a guillotine. If you miss the deadline by 1 day, even 1 hour, your claim is legally dead. It does not matter if you have video evidence of your boss admitting to firing you for a discriminatory reason. It does not matter if you have a dozen witnesses. If you miss the deadline, the courthouse doors are slammed shut in your face forever. And here's the terrifying part. These deadlines are shockingly short. For many federal discrimination claims, like those based on race, gender, religion, or disability, you must file a charge with the Equal Employment Opportunity Commission, or EEOC, first. And that deadline can be as short as 180 days from the date of the discriminatory act, the day you were fired. That's less than 6 months. Some states have their own agencies and give you a little more time, maybe 300 days. But think about that. You lose your job. You spend the first month in shock and processing. You spend the next 2 months desperately searching for a new job. You spend another month getting your feet under you at the new position. Boom! You're already 4 or 5 months in. You are dangerously close to that deadline without even realizing it. For other types of claims like certain wage and hour violations, the statute of limitations might be 2 or 3 years. But you can't know which deadline applies to your specific situation without speaking to a lawyer. You might think you have a simple breach of contract claim with a long deadline, but an attorney might spot a clear case of age discrimination that has a deadline that's just a few weeks away. Waiting isn't just a bad strategy. It's a gamble with the worst odds imaginable, because you're betting against a clock you can't even see. Every tick of that clock is a piece of your legal rights dissolving away. The company knows this. They are counting on you to be confused, to be overwhelmed, and to let that clock run out. And when it does, they've won without ever having to fight. So what is this invisible clock? You need to understand it's not just one clock. It's a whole wall of them, like something out of a spy movie, each one ticking down to a different critical deadline. And if any one of them hits 0, a door slams shut on your rights. Forever. The biggest, scariest clock on that wall is called the Statute of Limitations. It sounds like a complicated legal term, but its function is brutally simple. It's a legal kill switch. It is a hard, unchangeable deadline set by law for filing a lawsuit. If you miss it by 1 day, by 1 hour, even by 1 minute, your claim is legally dead. It doesn't matter if you have a recording of your boss admitting to firing you for an illegal reason. It doesn't matter if you have a stack of emails proving discrimination. If you file after the statute of limitations has expired, a judge will dismiss your case without ever even looking at your evidence. It's the legal equivalent of a game over screen. Let's talk about the most common one people face. The deadline for filing a discrimination claim. If you believe you were fired because of your race, your gender, your age, your religion, a disability, any protected characteristic, you can't just go straight to court. First, you generally have to file a charge with a federal agency called the Equal Employment Opportunity Commission, the EEOC. And the EEOC has its own ticking clock. In most states, you have only 180 calendar days from the date of the discriminatory act, the day you were fired, to file that charge. Let me say that again. 180 days. That sounds like a lot, doesn't it? Almost 6 months. Plenty of time to get your head straight, find a new job, and then think about your legal options. But let's see how that time actually disappears. Let's imagine Sarah. She's fired on January 1st. She's in shock. The first month, January, is a blur of disbelief, anger, and processing what just happened. She's updating her resume, starting to apply for jobs. She's not thinking about lawyers. She's thinking about her next paycheck. February comes. The reality of unemployment sets in. The bills are piling up. Her entire focus is on landing a new job. She tells her friends what happened and they say, "That sounds illegal. You should sue." But the idea feels overwhelming. A lawsuit? That's for other people. It sounds expensive, stressful, and confrontational. It's now March. She's had a few interviews, but nothing has landed yet. Self-doubt starts to creep in. Maybe it was her fault. Maybe she's not good enough. The anger she felt has faded into a kind of weary resignation. The thought of fighting her old company feels exhausting. By April, she finally gets a job offer. Relief washes over her. She starts her new role, and for the next 2 months, all her energy is poured into making a good impression, learning the ropes, and proving herself. Her old job feels like a distant nightmare. She just wants to move on and forget. Then, one day in late June, she's talking to a new coworker who mentions a friend who went through something similar and got a great settlement. A spark of the old anger returns. She thinks, you know what? What they did to me wasn't right. She decides to finally look into it. She does a quick Google search and discovers the EEOC's 180-day rule. She counts the days on the calendar. January, February, March, April, May, June. She's a few days away from the deadline. Panic sets in. She frantically starts calling law firms. Many won't even talk to her because the deadline is so close. They know they won't have enough time to properly investigate her claim, gather evidence, and draft the charge. The clock hits 0. Game over. Sarah had a potentially strong case, but because she waited, she lost her right to even try. Her 6 months vanished into the fog of shock, job hunting, and the simple human desire to avoid conflict. Now, some states have their own local anti-discrimination agencies that have what's called a work-sharing agreement with the EEOC. In those states, the deadline to file is extended to 300 days. But do you know if you live in one of those states? Do you know which agency to file with? Do you know if your specific type of claim falls under that 300-day extension or if it's still subject to a shorter, different state deadline? This is a maze. And your former employer is counting on you getting lost in it. But that's just for discrimination. What if your case isn't about discrimination? What if it's about a breach of your employment contract? Or unpaid wages and overtime? Or retaliation for being a whistleblower? Every single one of these claims has its own unique statute of limitations. In some states, you might have 2 years to sue for breach of a written contract. In others, it might be 4 or even 6. For unpaid wages, the deadline could be 2 years, but if the employer's violation was willful, it might extend to 3. Are you starting to see the wall of clocks? It's a dizzying, confusing mess of overlapping state and federal laws, and each one is a potential trap that can obliterate your case. An experienced employment lawyer knows this maze like the back of their hand. They know which clocks are ticking the fastest for your specific situation. Contacting them early is like getting a guide to lead you through that maze while you still have time. Waiting is like trying to navigate it blindfolded, with every tick of the clock making the walls close in. But even if you're well within the legal deadlines, there is another, more insidious clock ticking away in the background. This one doesn't have a hard stop, but it can be just as fatal to your case. This is the clock of decaying evidence. A legal case is not one on what you know to be true. It's one on what you can prove. And the proof, the evidence, has a shelf life. It degrades over time. First, human memory, the single most important form of evidence. Right after you're fired, the details are sharp in your mind. You remember the exact condescending phrase your manager used. You remember the date of that weird meeting where you were suddenly left out. You remember who was in the room when a crucial comment was made. 6 months later, a year later, those sharp details blur. You might remember the comment but not the exact wording. You might remember the meeting but not the date. The other side's lawyers will exploit this. They will pick apart your testimony, making you seem uncertain and unreliable. You're not quite sure what he said, are you, Miss Smith? You can't recall the date, can you? Every forgotten detail is a weapon they will use against you. Second, digital evidence. We live in a world of emails, text messages, Slack channels, and server logs. This is often the most powerful objective evidence you can have, but it is shockingly fragile. Many companies have automatic data deletion policies. Corporate emails might be permanently purged from the server after 90 or 180 days. Slack messages might disappear after 30 days. Key documents stored on a shared drive might be accidentally deleted or moved. By the time you get a lawyer, and they send a formal litigation hold letter demanding the company preserve all evidence, the most crucial proof might already be gone. Poof, vanished into the digital ether. Third, witnesses. That one sympathetic coworker who told you what they're doing to you is wrong, is your best ally. But what happens if you wait 6 months to act? In that time, they might quit and take a new job across the country. You lose their contact information. Or maybe they're still at the company but now they're scared. 6 months ago, they were angry on your behalf. Now they're worried about their own job, their own mortgage. They don't want to get involved. Their memory conveniently gets hazy. Their willingness to help evaporates. You see, while you are waiting, processing, and hesitating, your former employer is not. The moment they decide to terminate you, especially if it's legally questionable, their machine springs into action. Their HR department and their in-house lawyers are already building their defense. They are preserving the documents that help them and conveniently losing the ones that don't. They are interviewing the managers and witnesses involved to lock in the company's official, sanitized version of events. While you are trying to recover from the shock, they are building a fortress. Every single day you wait, you are handing them more bricks and mortar to build that fortress higher, while the evidence you need to fight back turns to sand and blows away in the wind. Let's talk about what that fortress is made of. The bricks are deleted emails. The mortar is the coached testimony of your former colleagues. The foundation is a paper trail you never even knew existed, suddenly appearing in your employee file, justifying a termination that just days ago they called a restructuring. While you're at home, staring at the ceiling, wondering what went wrong, their HR department and their in-house counsel are not. They are orchestrating a symphony of defense. The first thing that happens, often within hours of your departure, is a digital cleanup. Your email account, your access to company servers, your Slack or Teams messages, it's all wiped. But it's not just about locking you out. They are actively scrubbing the evidence. An IT manager gets a quiet directive: preserve business-critical data from the terminated employee's account, and follow standard data deletion protocols for the rest. And what is the rest? It's that email chain where your boss praised your work just last month. It's the direct message from a colleague complaining about the same harassment you experienced. It's the project file that proves you met every deadline they now claim you missed. They light a digital bonfire, and your proof goes up in smoke. It's not illegal. It's just company policy. But the moment a lawyer gets involved, that policy changes. Suddenly, they have a legal duty to preserve everything. But if you wait, there's nothing left to preserve. Then there are the witnesses. Your friends at the office. The people you had lunch with, the ones who saw what was happening. You think they'll have your back, right? You think they'll remember the truth. But the company gets to them first. There will be a team meeting. Maybe a one-on-one with HR. The narrative is set. Your departure is framed in a very specific, very careful way. Your former colleagues are reminded of confidentiality policies. They're reminded who signs their paychecks. Their memories start to get fuzzy. The manager who promised you a promotion? He now doesn't recall that specific conversation. The coworker who witnessed the inappropriate comment? She now says she might have misinterpreted it. They aren't bad people. They're scared people. They're protecting their own jobs, their own families. The company isn't twisting their arms. They're just gently, expertly guiding them to a version of the truth that protects the company. By the time you or your lawyer tries to talk to them weeks or months later, the company's story has become their story. The fortress walls are now lined with guards who used to be your allies. And this brings us to the most insidious brick in that wall: the retroactive paper trail. You'd be shocked how many undocumented verbal warnings suddenly become documented after you're gone. How a single minor mistake you made 6 months ago, which was resolved in 5-minute chat, is now memorialized as a formal counseling session for performance deficiencies. They can build a case for your termination after the fact, creating a file that looks like they had no choice but to let you go. And who's going to argue with it? You're already gone. You don't have access to the systems. You can't prove that that warning was never actually given to you. They are writing a history of your failure, and you're not even in the room to defend yourself. While all of this is happening, while the company is building its impenetrable fortress, a clock is ticking. It's not just a metaphorical clock. It's a very real, very unforgiving legal clock. It's called the Statute of Limitations. This is one of the most brutal and misunderstood concepts in the entire legal world. A statute of limitations is a hard, government-mandated deadline by which you must file a lawsuit or, in many employment cases, file a formal complaint with a government agency like the Equal Employment Opportunity Commission, or EEOC. If you miss this deadline, even by a single day, your claim is extinguished. Forever. It doesn't matter if you have a recording of your boss admitting to firing you because of your age. It doesn't matter if you have 100 emails proving discrimination. If you miss the deadline, your case is worth zero. You have no rights. The courthouse doors are locked and barred to you. And here's the terrifying part. These deadlines are often shockingly short. For many federal discrimination claims, you may have as little as 180 days from the date of the discriminatory act to file a charge with the EEOC. That's less than 6 months. 6 months from the day you were fired, or the day you were demoted, or the day you were last harassed. Think about that. You spend the first month in shock. The next 2 months desperately looking for a new job, updating your resume, going on interviews. Another month dealing with the financial fallout, juggling bills, figuring out COBRA. Suddenly you're 5 months in. You've just gotten your head above water enough to even think about fighting back. And you discover you might only have 30 days left before your rights evaporate into thin air. Some state laws give you more time, some claims have different deadlines, but the point is you don't know which clock applies to you. And every single day you wait, you are gambling with the only chance you have for justice. The company knows this. Their lawyers know this. They are counting on you to be overwhelmed. They are counting on your paralysis. They want you to be so focused on the immediate crisis of unemployment that you don't have the mental or emotional bandwidth to think about legal action. They might even offer you a small severance agreement, hoping you'll take the quick cash and sign away all your rights without ever reading the fine print. That severance offer isn't an act of kindness. It's a calculated business decision. They're betting a few $1,000s that you won't talk to a lawyer who could potentially win you a settlement that's 10 or even 100 times larger. They are using time and your own emotional state as a weapon against you. Every moment of delay is a victory for them. It's another email deleted, another witness's memory shaped, another page added to your fabricated file, another tick off that unforgiving clock. You feel powerless, like you're standing at the bottom of a mountain, and they're at the top rolling boulders down at you. You think waiting will make you feel stronger, clearer, but you're not getting stronger. You're just giving them more time to fortify their position. But what if I told you there's a way to stop it all? A way to freeze their entire operation in its tracks. There is a single action, a single document, that a lawyer can deploy that acts like a legal injunction against their entire defense-building machine. It is the very first and arguably the most powerful move you can make. It's a formal notice that legally obligates the company to stop their standard evidence destruction. It forces them to preserve every email, every instant message, every document related to your employment and your termination. It puts them on notice that the game has changed. They are no longer in control of the narrative. This one action rips the bricks from their hands and blows a hole in their fortress wall before it's even finished. And once that hole is blown, the company's reaction is immediate and predictable. They will scramble. They will call their own lawyers. Their internal counsel or a high-priced firm they keep on retainer will get a panic call from HR. And you might think, oh no, now they have lawyers involved. This is going to be a huge fight. Good. That's exactly what you want. You don't want to be an individual fighting $1 billion corporation. You want it to be a lawyer fighting a lawyer. You want it to be a fair fight, and this is the first step to leveling that battlefield. Their lawyers, upon receiving our legal hold notice, will do one thing immediately. They will tell the company to stop destroying evidence. The game of oops, the emails were automatically deleted, is over before it even begins. But let's talk about what that really means. What evidence are we actually preserving? It's so much more than just your termination letter or a few emails. We're talking about the digital breadcrumbs that tell the real story. Think about your company's internal chat system. Slack, Microsoft Teams, Google Chat. How many conversations happened there? How many times did your manager make an off-the-cuff remark that at the time seemed harmless, but now in the context of your firing, looks incredibly suspicious? Maybe they made a joke about you being old school, a week before they fired you for not being a culture fit. Maybe they complained about your medical appointments for your disability in a private channel with another manager. These are the conversations where people let their guard down. This is where the truth lives. And guess what? Most companies have automatic deletion policies for these platforms. Messages might be set to disappear after 30, 60, or 90 days. Your legal hold letter stops that clock. It freezes that evidence in carbonite. Then there's the performance improvement plan, the dreaded PIP. This is one of the most common tools companies use to build a fraudulent paper trail to justify a discriminatory or retaliatory firing. They'll put you on a PIP with impossible goals with subjective metrics designed for you to fail. They'll claim you weren't a team player or didn't meet expectations. But the legal hold allows your attorney to demand not just your PIP, but the PIPs of other employees. We can see if the goals they set for you were wildly different from the goals they set for your colleagues. We can see if anyone has ever successfully completed a PIP under your manager, or if it's just a conveyor belt to the exit. We can demand the data, the reports, the sales figures that they claimed you weren't hitting. We can compare them to the actual raw data. Suddenly, their carefully constructed narrative begins to fall apart under the weight of their own records. We can also preserve versions of the company handbook and internal policies as they existed while you were employed. This is critical. After you're gone, what's to stop them from quietly updating their HR policy to retroactively cover the shady thing they did to you? Nothing, unless a lawyer has sent a letter demanding they preserve the version that was in effect on your last day. We can even get things like access logs, keycard swipe data. Did they claim you had a poor work ethic and weren't dedicated? Well, the keycard data might show you were the first one in and the last one to leave every single day for 6 months. Every piece of data tells a part of the story, and the sooner you act, the more of that story we can save from the digital shredder. But sending that letter isn't just about freezing evidence. It's about another, far more terrifying concept in the legal world. It's a concept that has destroyed more valid, righteous, and winnable cases than any other. It's called the Statute of Limitations. Think of it like a countdown clock. The moment your employer takes an illegal action against you, the moment you are fired, demoted, or harassed, a hidden timer starts ticking. You can't see it, you can't hear it, but it is running. And if that clock hits 0 before you take formal legal action, your claim is gone. It evaporates. It doesn't matter if you have a video of your boss admitting to discrimination. It doesn't matter if you have a dozen witnesses. If the deadline passes, the courthouse doors are locked to you forever. The legal system, for better or for worse, values finality. It believes that disputes can't be allowed to linger forever, so it imposes these strict, and often brutal, deadlines. And here is the most dangerous part. That clock is not the same for every type of case. This is a minefield of dates and deadlines that is almost impossible to navigate without an expert guide. For some types of federal discrimination claims, you may have as little as 180 days from the date of your termination to file a charge with the Equal Employment Opportunity Commission, or the EEOC. That's less than 6 months. For other claims under state law, you might have a year or 2 years or 3. A breach of a written contract claim might have a different clock entirely. A wage and hour violation has another. You could easily have multiple potential claims, all with different clocks running simultaneously. Which clock applies to you? It depends on the facts of your case, the state you live in, and the specific laws your employer violated. Trying to figure this out on your own is like trying to defuse a bomb with a user manual written in a foreign language. One wrong move, one misunderstanding of a single date, and your entire case is lost. Let me tell you about a woman we'll call Jessica. Jessica was a top-performing sales director at a tech company for over a decade. She was in her late 50s and consistently exceeded her quotas. One day, she was called into HR and told her position was being eliminated due to a strategic restructuring. She was devastated. They gave her a small severance package. She signed the paperwork without a lawyer looking at it, and she spent the next 7 months focused on the difficult task of finding a new executive-level job at her age. She was grieving the loss of her career, she was stressed about money, and the last thing on her mind was a lawsuit. Then, about 8 months after her termination, she had lunch with a former colleague who was still at the company. Her friend told her the truth. There was no restructuring. Jessica's position wasn't eliminated. They had hired a 32-year-old man to fill her exact role, just with a different title. They were paying him significantly less. Even worse, her friend had overheard the VP of sales telling another executive that they needed to lower the average age of the sales team to present a more youthful, energetic face to clients. Jessica was floored. And then she got angry. This was a textbook case of age discrimination. She had witnesses. She had her performance reviews proving she was a star employee. She had the companies lie about restructuring in writing. She called an employment lawyer, ready for a fight. The lawyer listened to the story, and his heart sank. He agreed it was one of the strongest age discrimination cases he had ever heard. And then he asked the fatal question. What was your last day of employment? Jessica told him the date, and the lawyer had to deliver the gut-wrenching news. The deadline to file her age discrimination claim with the EEOC had passed 2 months ago. The clock had hit 0. Her slam dunk, righteous case was worth nothing. It was gone. Her delay was completely understandable from a human perspective, but from a legal perspective it was fatal. She waited. She focused on other things. She didn't know the clock was ticking. And the company, who knowingly and illegally discriminated against her, got away with it completely. All because of a deadline. This is why the answer to how soon is not when you feel ready. It's not after you find a new job. It's now. It's immediately. Because every single day you wait, you are giving your former employer a gift. You are letting evidence vanish, and you are letting that merciless legal clock tick 1 second closer to 0. So you've sent the legal hold. You understand the ticking clock. Now what? You have to actually speak to the lawyer. And what you say in that very first conversation is one of the most critical moments in your entire case. Most people make huge mistakes saying things they think are helpful but are actually incredibly damaging. And that's what we're going to break down next. The exact words to use and the deadly phrases to avoid when you make that first call. Alright, you're on the phone. Your heart is pounding. This is it. The first call to an employment lawyer. What you need to understand is that this isn't just you telling your story. This is an audition. The lawyer on the other end of the line, or more likely their intake specialist, is listening for very specific things. They are screening you. They're trying to figure out in less than 5 minutes if you're a credible client with a viable case, or if you're an emotional wreck with an unwinnable grudge match. Your first 60 seconds will likely determine whether you get a call back or a polite, "Sorry, we can't help you." So let's start with the landmines. The phrases that make a lawyer's internal alarm bells go off. These are the things you must avoid saying at all costs. Deadly phrase number 1. I just want justice. Look, I get it. You feel wrong. You want fairness. You want the universe to be set right. But in legal terms, justice is a meaningless word. It's vague. It's emotional. It tells the lawyer nothing about what you actually want. Does justice mean you want your job back? Does it mean you want $1 million? Does it mean you want your boss to issue a public apology? When a lawyer hears, "I just want justice," they often translate it to, "This person has unrealistic expectations and is driven by emotion, not logic." They will be difficult to manage, will likely reject reasonable settlement offers, and will be a nightmare to work with. You are immediately flagging yourself as a potential problem client. Instead of seeking justice, you need to think in terms of legal remedies, which we'll get to in a moment. Deadly phrase number 2. My boss was a complete jerk. Or any variation. A toxic bully. A micromanager from hell. The worst person I've ever met. Here is a brutal truth of American employment law. It is perfectly legal for your boss to be a jerk. It is legal for them to be unfair, to play favorites, to have a bad personality, and to make your life miserable. It's not right, but it's not illegal. When you lead with complaints about your boss's personality, you are telling the lawyer that you don't understand the fundamental difference between a bad boss and an illegal action. A lawyer's ears only perk up when they hear that the jerk behavior is tied to something specific and illegal. For example, was he a jerk only to the women in the office? Did his bullying start the day after you filed a complaint with HR? Did he micromanage you to the point of failure after you requested a medical accommodation? The reason for the jerk-like behavior is everything. The behavior itself is often just noise. Deadly phrase number 3. I know I have $1 million case. Never ever ever say this. You might think it shows confidence, but to a lawyer, it screams arrogance and delusion. You have no idea what your case is worth. Case valuation is an incredibly complex process that depends on dozens of factors. The strength of your evidence, the state you're in, the specific laws that were broken, the company's ability to pay, the judge you might get, and so much more. By throwing out a number, you've just told the lawyer that you have a wildly inflated expectation that they will now have to spend the entire case trying to manage. Good lawyers run from clients with lottery ticket syndrome. It's a sign that no matter what fantastic result they get for you, say a $100,000 settlement, you'll still be unhappy because it wasn't the $1 million you invented in your head. Deadly phrase number 4. Don't worry, I secretly recorded everything. This one feels like a trump card, right? You've got the smoking gun on tape. But this can backfire spectacularly. Many states, including major ones like California, Florida, and Pennsylvania, are two-party consent states. This means it is illegal to record a private conversation unless every single person in that conversation consents to being recorded. If you announce that you have illegal recordings, you've not only presented evidence that is inadmissible in court, but you've also admitted to potentially committing a crime yourself. You may have just tanked your own case before it even began. A much better way to handle this is to say, I have extensive documentation of what happened. Then let the lawyer, in the confidential setting of a consultation, ask you what kind of documentation you have. They will know the laws in your state and can advise you on how to handle it. Okay, so we know what not to say. You're not going to talk about justice, your boss's personality, $1 million fantasies, or illegal recordings. So what do you say? You use what I call the power script. It's a simple 4-part framework that presents your situation in the exact way a lawyer needs to hear it. It's clear, concise, and based on facts, not feelings. Part 1. The opening statement. It's simple and direct. Hello, my name is Jane Doe. I was terminated from my position as a senior analyst at ACME Corporation on October 26. I worked there for 7 years, and I'm calling because I believe my termination may have been illegal, and I'm seeking a consultation to understand my rights. Boom! In 15 seconds, you've given them everything they need. Your name, your former employer, your tenure, the date of termination, and the reason for your call. You sound professional, organized, and serious. Part 2. The factual timeline. This is the core of your story, but told like a reporter, not a novelist. For the first 6.5 years at ACME, I received exceeds expectations on every performance review. I have copies of them. 3 months ago, I submitted a formal complaint to Human Resources about my supervisor making inappropriate comments about my age, stating that the company needed fresh, young blood. 2 weeks after my HR complaint, I was placed on a performance improvement plan for the first time in my career, citing vague issues like not being a team player. I have a copy of that PIP and my written rebuttal. Last week, I was terminated for failing to meet the terms of the PIP. Do you see the difference? You didn't say your boss was a jerk. You stated facts. He made comments about your age. That points to potential age discrimination. You filed a complaint. That's a legally protected activity. You were then disciplined and fired shortly after. That points to potential illegal retaliation. You've connected the dots for them in a logical, chronological sequence. Part 3. The evidence summary. You've already hinted at this, but it's good to state it clearly. I've saved all relevant documents, including my past performance reviews, the email chain with HR about my complaint, the performance improvement plan, and my termination letter. This is music to a lawyer's ears. It tells them you're not just calling with a vague feeling of being wronged. You are organized. You have proof. You have the raw materials they can use to build a case. It instantly makes you a more credible and attractive potential client. Part 4. The professional ask. You end the call not with a desperate plea, but with a respectful business inquiry. Based on this brief summary, I was hoping to find out if this is the type of case your firm handles, and if so, what the process would be for scheduling an initial consultation. This framing is crucial. You are not a victim begging for a handout. You are a potential business partner presenting an opportunity. You are interviewing them as much as they are screening you. It shows respect for their time and positions you as a competent, rational person they would want to work with. This entire power script takes maybe 90 seconds to deliver. And in that minute and a half, you have communicated more valuable, legally relevant information than 95% of the other callers they will get that day. You have cut through the emotional clutter and presented the cold, hard skeleton of a potential case. You have transformed yourself from just another angry ex-employee into a serious potential client with a documented, fact-based claim. And that is how you get a call back. That is how you get your foot in the door. But getting that first meeting is only half the battle. Now you have to prepare for it, because what you bring to that meeting and what you forget to bring can be the difference between the lawyer taking your case on the spot or showing you the door. There is one category of documents that is the absolute lifeblood of any employment case, and there's another, seemingly innocent document that many people bring, which can actually convince a lawyer not to take your case. And that's exactly what we need to cover next. It's the severance agreement, or a separation agreement, or whatever your company decides to call the document they slide across the table, often with a sympathetic look, right after they've told you to pack your things. This document is the #1 reason a lawyer, after listening to a heart-wrenching story of injustice, will lean back in their chair, sigh, and say, "I'm sorry, there's nothing I can do." Why? Because buried in that dense, boring legalese is almost always a clause called a general release of claims. And it is exactly as powerful and devastating as it sounds. By signing that paper and accepting that check, which always feels too small, you are, in the eyes of the law, formally agreeing to release your former employer from any and all legal claims you might have against them. It doesn't matter if they violated the law. It doesn't matter if you discover damning evidence a month later. You have signed a contract forfeiting your right to hold them accountable. You've essentially sold your right to justice for the price of a few weeks' pay. Let me paint you a picture. Imagine a woman named Maria. She's 54, a top performer in her sales department for over a decade. One Tuesday, she's called into an unexpected meeting with HR and her new, much younger manager. They tell her they're restructuring, and her position has been eliminated. They praise her years of service, hand her a folder, and tell her she'll get 6 weeks of pay if she signs the agreement inside and returns it within the week. Maria is in shock. Her mind is a whirlwind of panic. The mortgage, her daughter's college tuition, her own future. The 6 weeks of pay feels like a lifeline, a tiny raft in a stormy sea. She's hurt, she's confused, but she's also practical. She needs that money. So she goes home, signs the paper, and sends it back. A week later, the direct deposit hits her account, and a wave of temporary relief washes over her. 2 months go by. She runs into an old, trusted colleague at the grocery store. The colleague looks around conspiratorially and says, "Maria, what they did to you was criminal. You know they hired a 28-year-old to fill your exact role, right? They just changed the title. The manager told me he needed someone with more digital age energy on the team." Suddenly, everything clicks into place for Maria. The vague reason for her termination. The new young manager. It's a textbook case of age discrimination. Furious, armed with this new information, she gathers her performance reviews, her sales records, and she marches into an employment lawyer's office. She lays it all out. The lawyer is nodding, seeing a clear, strong case. And then the lawyer asks the question, "Did they offer you a severance package?" "Yes," Maria says proudly. "I have a copy of the agreement right here." She hands it over. The lawyer's face changes. He flips through the pages, his finger stopping on that one soul-crushing paragraph, the general release of claims. And he has to deliver the news. "Maria, I believe you. Every piece of evidence here points to illegal age discrimination. But you see this? You've signed away your right to sue them for it." "My hands are tied." Maria's strong case, her righteous anger, her proof. It all evaporated into thin air the moment her pen touched that line. The company paid a tiny fraction of what a lawsuit would have cost them to purchase a legal shield, and Maria, under duress and without understanding the consequences, sold it to them. Now, is that signature an absolute, unbreachable fortress? Not always, but breaking it down is like trying to scale a castle wall with your bare hands. You can try to argue you were a victim of fraud or duress, but that's an incredibly high bar to clear. The financial pressure of losing your job on its own is almost never considered legal duress. You'd have to prove they physically threatened you or lied about a material fact in the document itself. However, there is a powerful exception, a chink in the armor that everyone, especially workers over 40, needs to know about. It's called the Older Workers Benefit Protection Act, or OWBPA. Congress knew that older workers could be vulnerable to being pressured into signing away their rights. So they created a specific set of rules that a company must follow for a severance agreement to be valid in waiving an age discrimination claim. For the release to be considered knowing and voluntary under the law, the agreement must be in writing and easy to understand. It must specifically refer to your rights under the Age Discrimination in Employment Act (ADEA). It must advise you in writing to consult with an attorney before signing. It must give you at least 21 days to consider the agreement. And critically, it must give you a 7-day period after you sign to revoke your signature. If the company is laying off a group of employees, they have to give you 45 days to consider it, not 21. If your severance agreement is missing any of these elements, a lawyer may be able to invalidate the waiver of your age discrimination claim. The company's legal shield crumbles. This is why you never ever rush to sign one of these documents. That 21-day consideration period isn't a suggestion. It's a federally mandated cooling-off period designed for one purpose: to give you time to take that document to a lawyer. Think of it this way: that unsigned severance agreement is not a final offer. It's an opening bid. The company is not giving you a gift. They are attempting to conduct a transaction. They are buying your legal rights. And before you sell something that valuable, you need an expert to appraise it. The lawyer is that appraiser. You bring them the proposed deal, and they can tell you if you're being offered a fair price, or if you're about to sell a winning lottery ticket for the price of a cup of coffee. When you walk into a lawyer's office with an unsigned severance agreement, the entire dynamic shifts. The lawyer reviews it, and they also review the facts of your termination. Maybe they see a clear case of discrimination, or retaliation for reporting an issue, or an illegal FMLA violation. Suddenly, that 6 weeks of pay the company offered looks insulting. The lawyer can then go back to the company on your behalf. They don't file a lawsuit, not yet. They just pick up the phone. They explain that the offer is insufficient given the potential legal claims at stake. They highlight the company's risk, the cost of litigation, the damage to their reputation, the potential for a large jury verdict. And in many cases, the company wanting to avoid that risk will come back with a much better offer. More severance pay, extended health insurance coverage, a neutral job reference. The negotiation is possible only because you haven't signed yet. You still hold the power. You still own your claim. Bringing a lawyer a signed severance agreement is asking them for a miracle. Bringing them an unsigned severance agreement is asking them for their professional expertise. One is a desperate plea, the other is a strategic business move. That single piece of paper and whether or not your signature is on it can be the difference between a tragic story of what if and a successful outcome that provides you with the financial cushion and the justice you truly deserve. So we've established the critical importance of documents, especially that severance agreement. But what you bring to a lawyer is only half the battle. What you do in the hours and days after you're fired can be just as important and just as destructive. There are a series of common instinctual reactions to being fired that can absolutely poison your case from the start, long before you ever even think about talking to an attorney. And the number one mistake involves your keyboard. The moment you're fired, your mind is a whirlwind of shock, anger, and fear. Your first instinct is to react, to lash out, to defend your reputation, to tell your side of the story to anyone who will listen. And in the digital age, your keyboard feels like the most powerful weapon in your arsenal. It is also the fastest way to destroy any chance you have of legal recourse. Let's talk about the post-termination email. You're sitting at home, hours after being walked out of the office. The injustice is burning a hole in your stomach. So you open your laptop, you start typing an email to your former boss or maybe to HR. Or maybe you get really bold and you CC the entire executive team. You pour all of your frustration onto the page. You list every grievance, every broken promise, every bit of unfairness you endured. You call out your manager for their incompetence. You accuse your colleagues of backstabbing you. You hit send, and for a fleeting moment you feel a sense of vindication. Justice. What you've actually done is hand-deliver the prosecution's opening argument against you. That email is now a permanent, discoverable piece of evidence. Every word you wrote will be scrutinized by the company's lawyers. They will use it to paint a picture of you as an unstable, disgruntled, and difficult employee. They'll argue that your email is proof that you were a problem, that you had a bad attitude, and that your termination was not only justified but necessary for the health of the company. Your legitimate claims of, say, age discrimination or retaliation for reporting harassment, they get buried under the mountain of your own emotional outburst. The jury will see your angry words, not the company's illegal actions. You've essentially written a character reference for the other side, and you signed your name to it. But it doesn't stop with email. In some ways, social media is even more dangerous. You post a long rant on Facebook or LinkedIn. You tweet a series of angry messages tagging your old company. You think you're just venting to your friends and followers. But you're not. You're publishing your case to the world, and the company's lawyers are taking screenshots. A post that says, "My boss was a snake and the whole company is corrupt," can be twisted into a potential defamation claim against you. Even if it doesn't rise to that level, it still serves the same purpose as the angry email. It wrecks your credibility. Future employers will see it. A judge or jury might see it. It makes you look impulsive and unprofessional. When you're in a courtroom trying to present yourself as a calm, rational victim of illegal corporate behavior, the opposing attorney will gleefully present a giant printout of your "they'll rue the day" LinkedIn post and ask, "Does this seem like the behavior of a reasonable professional?" Even private text messages to former coworkers are a minefield. You might text your work buddy, "I can't believe they fired me after everything I did. I'm going to make them pay for this." You mean it financially through a lawsuit, but the company's lawyers will frame it as a threat. They will subpoena those text records. Your friend, who doesn't want to lose their own job, will be forced to testify about your conversation. Suddenly, your quest for justice is portrayed as a vengeful personal vendetta. The bottom line is this: from the second you are terminated, you must assume that every single word you type is being read by the opposing counsel. Because one day it might be. The digital mistakes are the easiest to make, but the verbal ones are just as deadly. The first trap is often the exit interview. HR will present it as a friendly chat, a chance for you to provide valuable feedback. It is not. The Human Resources Department's primary function is to protect the company from legal liability. The exit interview is a fact-finding mission for them, not a therapy session for you. They are trying to get you on the record. They will ask leading questions like, "Aside from the issues we discussed today, Were you generally happy with your time here? Or, do you have any other concerns you'd like to share? If you say, no, everything else was fine, you have just potentially waived your right to bring up the 6 months of harassment you endured from your supervisor. If you unload on them with a disorganized, emotional account of everything that went wrong, they will document it in a way that serves the company's narrative, noting your agitated state and unsubstantiated accusations. The best way to handle an exit interview is to be polite, professional, and profoundly boring. Keep your answers brief and non-committal. I'm here to return my equipment and finalize my paperwork. I'm not prepared to offer detailed feedback at this time. Thank you for the opportunity. That's it. Do not sign anything, especially not a document that tries to summarize your conversation, without having a lawyer review it first. So, if you're not supposed to write, post, or talk, what are you supposed to be doing in those first few hours and days? You should be shifting from an emotional reactor to a strategic evidence collector. Your memory is a crucial asset, and it's never sharper than it is right now. Before the details start to fade, you need to create a detailed, written timeline of your employment. Open a document and start from the beginning. Day 1. What was your start date? What were you hired to do? Document every promotion, every pay raise, every positive performance review. Note down the specific dates and the key players. If you have copies of those reviews or emails from your boss praising your amazing work on the Q3 project, save them. These documents are vital to establishing that you were a competent, valued employee. This counters the inevitable narrative that you were fired for poor performance. Then document the turn. When did things start to go wrong? Was it when a new manager took over? Note the date. What was the first incident of discrimination, harassment, or retaliation? Write down the exact date, time, and location. Who was present? What was said verbatim as best as you can recall? Write down direct quotes. He said, "We're looking for fresh blood around here," while looking directly at me. That is infinitely more powerful than, "I think he was hinting that I was too old." Record every single time you reported the issue. The date you told your manager. The date you emailed HR. The date you had a follow-up meeting. Who did you speak with? What was their response? Did they promise to investigate? Did they tell you to just try and get along? If you have emails related to these complaints, they are pure gold. This documentation is what separates a he said, she said situation from a powerful retaliation claim. Finally, document the termination itself. The date, the time. Who was in the room? What was the exact reason they gave you for your termination? Write it down. If they said, "We're eliminating your position," but you know they hired someone half your age for the same job 2 weeks later, that specific documented reason becomes the lie your lawyer can expose. This timeline isn't just for your lawyer. It's for you. It takes the chaotic storm of emotions and facts swirling in your head and organizes it into a coherent, powerful narrative. It allows you to see the full picture, to connect the dots between your complaint and your termination, between your stellar performance record and the company's flimsy excuse for letting you go. When you finally do sit down with an attorney, you won't be empty-handed and flustered. You'll be handing them a roadmap to your case. You've avoided poisoning the well with angry emails, and you've started digging a new well of credible, organized evidence. But even if you do all of this perfectly, avoiding every digital landmine and documenting every detail, your former employer has one last powerful tool they will use to try and silence you forever. It's a document that looks like a gift, but it's actually a trap. And signing it without understanding it could be the single most expensive mistake of your entire career. We're talking about the severance agreement. It's a contract, a simple exchange. They give you a sum of money, maybe a few weeks or a few months of pay, and in return you give them everything. You give them your silence. You give them your story. And most importantly, you give them your right to ever hold them accountable for anything they ever did to you. The core of every severance agreement, the beating heart of this entire document, is a clause called a general release of all claims. Sounds boring. It sounds like standard legal boilerplate, but it is the most dangerous and one-sided legal weapon a company can wield against a former employee. When you sign that release, you are wiping the slate clean for them permanently. You are agreeing in a legally binding way that you will never ever, for any reason, sue the company for anything that happened during your entire time there. Think about what that means. Let's say a week after you sign, you're talking to an old coworker who reveals that the real reason you were let go was because your new manager was openly telling people he needed to get rid of the old guard, and that you were targeted because of your age. That's blatant age discrimination. But you signed the release. Your rights, gone, vanished into thin air. Or imagine you discover months later through an industry audit that your company had been misclassifying you for years, cheating you out of thousands of dollars in overtime pay. A clear violation of the Fair Labor Standards Act. A lawsuit that could have netted you double the back pay you were owed. But you signed the release. That money stays in their pocket forever. Harassment you endured, promises that were broken, a promotion you were denied because of your race or gender, retaliation you faced for reporting an ethical violation. Every potential legal claim, known or unknown, suspected or unsuspected, is extinguished the moment your ink dries on that page. You are essentially selling your entire legal history with that company for the price of a few paychecks. And the company knows exactly what a bargain they're getting. They aren't giving you a gift. They are buying an insurance policy against their own misconduct. And you are the one selling it. But the release of claims is just the beginning of the minefield. Buried in the dense paragraphs that follow are often a series of other traps designed to control your life long after you've left the building. Let's talk about the non-disparagement clause. This is the muzzle. It says you cannot say or write anything negative about the company, its products, its management, or its employees. Ever. To anyone. The language is usually incredibly broad. Does that mean you can't leave an honest negative review on Glassdoor? Yes. Does it mean you can't tell a friend at a barbecue that your old boss was a micromanager? Could. If they find out, they can sue you not just for the entire severance amount back, but for damages to their reputation. They've bought your silence, and they will enforce the terms of the sale. Paired with this is often a confidentiality or non-disclosure clause. This says you cannot even discuss the terms of the severance agreement itself. You can't tell your former colleagues how much you got, because the company doesn't want them getting any ideas about their own value if they're next on the chopping block. It creates a culture of secrecy and isolation, preventing employees from sharing information and understanding what's fair. And then there's the big one, the career killer, the non-compete clause. Sometimes, companies will use the leverage of a severance payment to get you to sign a non-compete agreement that is far more restrictive than anything you had before, or to get you to sign one for the very first time. They'll offer you 2 months of pay, and in exchange, you agree not to work for any competitor, in any capacity, within a 100-mile radius for 2 years. Think about that. They are paying you to take yourself out of the job market. They are paying you to cripple your own career. For someone in a specialized industry, a clause like that can be a financial death sentence. You're forced to choose between uprooting your family and moving, switching careers entirely, or sitting on the sidelines while your skills and contacts grow stale. It's a devastatingly effective way for a company to neutralize a potential competitor. You, for pennies on the dollar. Now, as you're sitting in that sterile HR office with this document in your hands, you'll likely feel an immense amount of pressure. And that pressure is a carefully engineered tactic. They will often give you an impossibly short deadline. We need this signed by the end of the day. You have 24 hours to decide. Why? Because your panic is their best friend. They know that if you're scared about your next mortgage payment, you're more likely to grab the immediate cash without thinking. They are trying to rush you into a decision before you have time to calm down, read the fine print, and most importantly, before you have time to contact a lawyer. They want you to make a permanent decision based on a temporary fear. But here is something they might not tell you. A critical piece of information that shifts the power back to you, especially if you're an older worker. Under a federal law called the Older Workers Benefit Protection Act, or OWBPA, if you are 40 years of age or older and are offered a severance agreement as part of a layoff, the company is legally required to give you a minimum of 21 days to consider the offer. Not 24 hours, 21 days. And even after you sign it, the law gives you a 7-day window to revoke your signature. This law exists precisely to combat those high-pressure tactics and to give you time to seek legal counsel. If a company is pressuring a 50-year-old employee to sign in 48 hours, they are not just being unethical. They may be breaking the law. And this brings us to the most empowering truth about that document in your hands. It is not a command. It is an offer. It is the start of a negotiation. The first number they slide across the table is almost never their final number. Everything is potentially negotiable. The amount of money, the length of the non-compete, the wording of the non-disparagement clause. You can ask for them to continue paying for your health insurance. You can ask for a positive letter of recommendation or an agreement on what they'll say when future employers call for a reference. But you can't negotiate effectively if you don't know what your leverage is. And what is your leverage? It's the strength of the legal claims you are giving up. If they know you were the victim of clear-cut discrimination, the value of your signature on that release is astronomically higher than if it was just a standard, no-fault layoff. They aren't paying you for your years of service. They are paying you to avoid a lawsuit. The more credible the threat of that lawsuit, the more they are willing to pay. This is the cold, hard calculus of the situation. And this is precisely where a lawyer becomes not a cost but an investment. You don't know what you don't know. You can't spot the illegal non-compete clause. You don't know that the release language is overly broad and unenforceable in your state. You don't know that you have a slam-dunk wage claim that's worth 10 times what they're offering you in severance. An employment lawyer reads these documents every single day. They see the traps, the tricks, and the hidden leverage points instantly. They can assess the strength of your potential legal claims and put a real dollar value on what your signature is worth. Often, a single strongly worded letter from an attorney can dramatically increase the severance offer, more than paying for the lawyer's fee. They can turn the company's attempt to buy your silence into an opportunity to secure your future. Signing that document without legal review is like walking blindfolded into a minefield, hoping you get lucky. The moment that severance agreement touches your hand is the moment the clock starts ticking on the most important financial decision of your career. It is the absolute, undeniable loudest signal you will ever get that you need to make a phone call, because the company already has their lawyers. They wrote the agreement. And going into that negotiation alone is a battle you are almost guaranteed to lose. Now let's be crystal clear about what a severance agreement is. It is a legal document, drafted by the company's lawyers, for the sole purpose of protecting the company. Its primary function is to get you to sign away your right to sue them forever, in exchange for a sum of money they hope is just enough to make you go away quietly. They have a team of people who have analyzed the risks. They have calculated the potential cost of a lawsuit versus the cost of your severance. They have weighed every single word in that document to give them the maximum possible advantage. You, on the other hand, have you. That's it. Just you, your emotions, and a ticking clock they've imposed, often telling you that you only have a few days to decide. It's an intentional, high-pressure tactic designed to prevent you from doing the one thing they fear most: getting an expert in your corner. So we've spent all this time talking about the signals, the red flags, the moments that should make you think about calling a lawyer. But let's flip the question. Let's not ask, should I call a lawyer? Let's ask, what is the cost of not calling? The cost is signing away a potential claim worth tens, or even hundreds of thousands of dollars, for a few weeks of pay. The cost is accepting a narrative that you were a poor performer, when you know you were a star, a narrative that can follow you and damage your future career prospects. The cost is the lingering, corrosive feeling of injustice, the what if that will eat at you for years to come. The cost is letting a company that broke the law get away with it, potentially allowing them to do the same thing to someone else down the line. When you look at it that way, the question isn't whether you can afford to make the call. It's whether you can truly afford not to. Let's quickly recap the major alarm bells we've discussed. The moments when picking up the phone goes from a maybe to a must-do. First, there's the gut feeling. The termination that just doesn't make sense. The explanation that feels hollow. You were a top performer, praised in your last review, and now suddenly you're being let go for restructuring, while your less productive colleague keeps their job. Your intuition is one of the most powerful tools you have. Don't ignore it. Second, the suspicious timing. This is the flashing neon sign. You were fired a week after you filed a complaint with HR about harassment. 2 weeks after you told your boss you were pregnant. The day you were scheduled to return from medical leave. The law has a name for this: retaliation. And it is one of the clearest paths to a wrongful termination claim. Third, you see a pattern. You're over 50 and you notice that everyone else in the layoff was also over 50. Or you're the only woman on your team, and you're the one who got cut. Or you notice that everyone who has spoken up about safety concerns has mysteriously been phased out. If you are part of a protected class based on your age, race, gender, religion, disability, and so on, and you see a pattern affecting people like you, that is a massive red flag. And fourth, as we just covered, the paperwork. The second you are handed a severance agreement or any document that asks you to release the company from all claims, the game has changed. You are no longer just an employee being let go. You are a party in a legal negotiation, whether you realize it or not. If you've experienced any one of these, you have a compelling reason to seek advice. If you've experienced more than one, it's not even a question. Now, I know what the single biggest hesitation is for almost everyone watching this. It's the four-letter word that stops people in their tracks. You're thinking, I just lost my job. I have no income. The last thing I can do is hire a high-priced lawyer. This is a completely understandable fear. And it is based on a massive misconception. Most reputable employment lawyers do not work like the lawyers you see on TV, billing hundreds of dollars an hour for every phone call and email. Instead, they work on what's called a contingency fee basis. Let me say that again because it is the most important financial concept you need to understand right now. A contingency fee basis. What does that mean? It means they only get paid if you get paid. Their fee is a percentage of the money they recover for you, whether that's through a settlement or a court verdict. If they don't win your case, you owe them nothing in attorney's fees. 0. This arrangement does two incredible things. First, it gives everyone, regardless of their financial situation, access to justice. It levels the playing field between you, an individual who just lost their income, and a multi-million or multi-billion-dollar corporation. Second, it means the lawyer is directly invested in your success. They won't take your case unless they genuinely believe it has merit and a real chance of winning. Their success is literally tied to your success. And it gets even better. The first step, the initial consultation, is almost always free. You can call a law firm, explain your situation to an experienced attorney or their intake team, and get a professional preliminary assessment of your case without spending a dime. Think of it as a free expert diagnosis for your career. You have absolutely nothing to lose from this first conversation, and a world of clarity to gain. So what actually happens on that first call? Let's demystify it because the fear of the unknown also stops people. It's not a scary interrogation. It's a conversation. You will tell your story. You'll explain who you worked for, what you did, how long you were there, and the circumstances of your termination. Then the lawyer will start asking questions. And these will be questions you probably haven't even thought to ask yourself. When was your last pay raise? Did you get it in writing? What was said in your last performance review? Do you have a copy? Did you ever email HR about any issues? Did anyone else witness the behavior you complained about? Does the company have an employee handbook? They aren't just getting the facts. They are searching for the legal hooks. They are looking for the evidence, the documentation, and the witnesses that can turn your gut feeling into a legal cause of action. At the end of that conversation, one of three things will likely happen. 1, they'll say, based on what you've told me, I think you may have a strong case and here's why. 2, they'll say, this is a tough situation, and while it feels unfair, I'm not seeing a clear violation of the law here and here's why. Or 3, they'll say, I need more information. Can you send me your performance reviews and that severance agreement? Notice that in every one of those outcomes you win. Even if they tell you that you don't have a case, you have gained something incredibly valuable: certainty. You can now move forward with your life, knowing you explored the option and got an expert opinion. You've replaced anxiety and wonder with a concrete answer. But if they tell you that you do have a case, your entire world changes in that moment. You go from being a victim of a bad situation to an active participant with leverage and a path forward. You are no longer powerless. So, to finally and definitively answer the question of this video, how soon should you contact a lawyer after losing your job? The answer isn't a set number of days or weeks. The answer is a moment. It's the moment your gut screams that something is fundamentally wrong. It's the moment you realize the reason you were given for being fired is a lie. It's the moment you're staring at a legal document designed to silence you. That is the moment. You should make the call as soon as possible after that moment arrives. Because time is not on your side. There are strict, unyielding deadlines for filing claims, known as statutes of limitations. For some types of claims, you may only have 180 or 300 days from the date of your termination to act. If you miss that deadline, your claim is gone forever, no matter how strong it was. Evidence also disappears. Emails get deleted, documents get shredded, and coworkers who might have been witnesses move on to other companies and forget key details. The longer you wait, the harder your case becomes. Losing your job is a deeply personal and often traumatic event. But it does not have to be the end of your story. It can be the beginning of a new chapter where you stand up for yourself. The company has their lawyers. Their only job is to protect the company's interests. You deserve to have someone in your corner whose only job is to protect yours. Don't let fear, uncertainty, or a misplaced sense of loyalty to a company that just fired you make this decision for you. Make the call, get the facts, and take back control of your story.